Good morning, everyone. I'm going to go ahead and call the Senate Judiciary Committee to order. I want to thank everyone for being here on a Friday. This is one of those unique days as we get closer to the deadlines, and today is a deadline. We're picking up an extra day for our committee, and so we got 3 bills that we're going to be taking public hearing on only. As I stated previously on the record, today's intent is to actually get the information before the committee, and then we'll take action afterwards because of other obligations that some of the members have had. I know Senator Lithcom is not going to be with us today, and I believe that some of the other members may need to be coming and going. So, and I see Senator Bench was able to get here a little bit earlier than we thought, so that's good. I was making all of our exceptions for apologies and all that before we got there, but he's here, so I think we're going to go ahead and get started with public hearing on Senate Bill 35A.
Chair Przanski, members of the committee, we've had a lot of discussion about guardianships in committee this session, but today we're going to talk about conservatorships in regards to Senate Bill 35A. A conservatorship is a protective proceeding in which a person is found to be either a minor or financially incapable and has money or property that requires management. Conservators are required to give an annual reporting to the court detailing their administration of the protected person's money or property, and within that annual accounting, a conservator must provide vouchers for disbursements unless the conservator is a trust company in compliance with ORS 709.030. The Oregon Department of Veterans Services provides conservatorship services for veterans who, and the conservators in that program have expert management skills with U.S. Department of VA benefits and other associated benefits and programs. Senate Bill 35A exempts ODVA from the requirement to provide vouchers in its annual accounting to the court when serving as a fiduciary. That's the first part of the bill. The second part of the bill also deals with grant programs for campus veterans services and allocates funding towards those programs and removes the sunset on the grant program. That isn't necessarily a topic of conversation pertinent to this committee, but it was referred to us to look at the conservatorship issue.
Yeah, and that's one thing for the record, for those who are following, this bill was referred to the committee for that specific purpose, and that's kind of where we're at and focusing regarding the issues of, say, the policy stuff has been handled in the Committee on Veterans and Emergency Preparedness. And so today we're going to be hearing from at least 2 individuals. I have Chad Brown and Laurie, and I believe it's Stillman. If you two would please come forward. And I'm going to ask if there's anyone else who will want to be giving testimony today on Senate Bill 35A.
And down.
Well, thanks to both of you for being here. I'm not sure who would like to lead off, but give us your name first and then your testimony, please.
Sure. Good morning, Chair Przanski, members of the committee. For the record, my name is Laurie Skillman. I'm the Senior Policy Advisor for the Oregon Department of Veterans Affairs. This is an ODVA bill. We, as a council and the chair so eloquently talked to you about our bill. I have just a little bit to say about it. Our conservatorship program serves about 140 of our most fragile veterans who are unable to manage their own finances. This is only conservatorship. This is not guardianship in any way. So this is just managing financial issues for that individual. All of that has strict scrutiny by our courts. Everything that the conservators do in our conservatorship program, they have to file documents with the court, talk about how these funds have been spent, and file financial documents. The way that the statute is written is that if you are a conservatorship and you're not a trust company, and the purpose of the program is to put us on the same playing field as trust companies, is that you have to file vouchers, which are just canceled checks, and like a bank statement. The reason this is kind of a challenge for us is that all of our funds are placed in the state treasurer. And instead of having individual accounts, like you'd have individual bank accounts for your clients at a bank, we have a pooled account for all of our clients. So in order to pull out the individual records on these transactions and checks, it is a very labor-intensive process for our conservators to pull out these individual documents for individual clients. We do provide the full record, but to actually hand over the canceled check instead of a documentation of all of that is just labor intensive. So this is just a streamlining bill for the agencies so that we can do things efficiently and quickly. And as Council Newell said, this puts us on par with trust companies who are also allowed to do this very thing. And let's see, let me just, the streamlined process would allow ODVA to keep vouchers on file and provide them to any interested party. And this just aligns the court filing requirements with court filing requirements for trust companies. So if you have questions about that, I'm happy to answer those. Let me tell you, as the chair mentioned, there's another piece to this bill, and it's because our statutes on the Campus Veteran Services Program, which is a grant program that was heard down in Senate Veterans, was due to sunset January 2nd, 2020. And that grant program is a huge success. So the bill that we added that to this bill, I know it seems a little odd, kind of at the last minute, to remove the sunset and make that permanent. While it was down in Senate Vets, the committee amended the bill, and that's why it's 35A, and the amendment was to put in a provision that allocated $1.2 million to the Campus Veterans Program. Just for your information, the agency in the governor's recommended budget put $700,000 toward this program, and the Senate committee felt that wasn't sufficient, so they bumped it to $1.2 million. As you know, the agency stands by the governor's recommended budget. Thank you so much. If you have any questions, I'm happy to answer them.
All right, thank you. Before we take questions for Laurie, Chad, why don't you give us your testimony, then we'll open it up for comment.
Thank you, Mr. Chair, Madam Vice Chair, members of the committee. For the record, my name is Chad Brown. I am a senior at Oregon State University, and I also represent Student Veterans of America and Student Veterans of Oregon, which is an organization of 7 public universities and community colleges that have come together around the Campus Grants Program. Something that we all have differences of opinion on many different issues, but this is a program that we believe is so important and vital to our student veterans and our success that we all came together around this issue. I'm really mainly here today for support of just the Campus Grants Program. I understand that this hearing is about more than that, but we wanted to be represented here to talk about the 3 main things that we are very proud of what this bill will do. 1, removing the sunset clause, as Lori mentioned, the ability to have this program that has been innovative and one of the best things for student veterans across the nation, really, to be continued, we feel is very important. 2, as the Senate Veterans Committee did allocate for more money for this, because we do believe that if it's something that is so innovative, that is very productive and has been successful in its short time, that we consider that investing further makes it more important. And 3rd, the ability to have hired more competitive and professional staff for our veterans on our on our campuses, and that's something that the bill also allows for us to do. With that, I have any questions I'm willing to take.
All right, thank you. I will open up for questions. Are any questions? Senator Pence, please.
Thank you, Mr. Chair. And forgive me, I'm not very familiar at all with how the money is managed. But in the conservatorships that I have managed in our law office over the years, we, of course, turned in the vouchers to the court so the court could make sure no one was stealing the money. And on the trust side of things, the remedy in the event somebody was embezzling was the thought that you could sue the trust company. There would be recompense there if somebody discovered that was happening. Can you explain why that's not a concern here?
I think part of it is that that the funds and the checks that are written, on behalf of our conservatorship clients go to pay certain bills and certain things that they have. All of the money is in the state treasurer's fund. It's not in a bank. Our conservators there are 3 different levels of checking on the disbursements from these funds. The conservator, the 2 managers, and then our finance and accounting before they even go over to treasurer's office. So there's a lot of internal oversight before those things are even sent over there. Then the accounting has to be to the courts, just like with trust companies. So it's all that accounting is documented in there. There's no. I'm just not sure if I could be creative enough to figure out a way to embezzle funds out of our conservatorship accounts, but all of those are records that have to go, and they are audited internally and checked over by finance and accounting. So.
Mr. Chair, right, and I was unaware of those other levels of oversight. That's not the case in many of the conservatorships I have seen. There was just a conservator.
Sure.
And then the court would review what the checks were written for. That was the level of oversight, but you've explained there are 3 others, and so thus why add a 4th is your point in this bill.
And Chair Przansky, Senator Bentz, I think that I just lost my thought. Sorry.
All right, so the other question I guess I was going to just follow up on, based on what Senator Bench has stated, it sounds like, I mean, there are enough cross-checks and balances to make certain. Is there a monetary amount that if the check is going to be dispersed for $2,000 versus $500, that you have like another set of eyes to approve that type of removal, or?
What is it? Just tell me what it is.
I don't know what the amount is, but there is certain limits that are placed on the trust officers, and then on top of the managers, and then on top of the manager on top of that.
Right. Those are the 3 levels
Okay.
of kind of checks and balances.
Okay,
Yeah.
that's fine. I just want to make sure we had that on the record, because it seems like everything's in play and it has the appropriate oversight. Any other comments, questions? All right.
Senator?
Yes.
Mr. Chair, with the oppressive deadlines, we would also request that this bill be scheduled for work session. And, council knows that, and I just wanted to bring that to your attention, that we could hopefully schedule this for work session sometime.
Yeah, and just for the record, we will have it scheduled. As I started the beginning of our meeting, I purposely had these listed only for public hearing because this is a unique time for us as a
Yes.
committee. And I knew that at least one of the senators wasn't going to be here, and as much as I know you want this to get through sooner than later, I also like to honor my committee members for they can be here for votes. It will be scheduled, I believe it's scheduled for next week actually scheduled for the 3rd.
Thank you so much.
And so it should be posted. If it isn't, it will be definitely posted by the end of today.
Thank you,
All
sir.
right.
Thank you so much.
Thank you. With that, unless there's someone else who wants to give testimony on Senate Bill 35A, I'm going to go ahead and close the public hearing. And we're going to open up a public hearing on Senate Bill 762. Shannon?
Chair Przanski, members of the committee, Senate Bill 762 is a product of the interim work group on decriminalizing mental illness. Under current law, a person may be held in a hospital or facility for involuntary treatment if the person is a danger to self or others and is in need of emergency care or treatment. Currently, that period for involuntary detention is not more than 5 judicial days following admission. In a handful of states, as we learned within the work group, there are a variety of lengthier hold periods. Senate Bill 762 extends Oregon's 5-day detention to 15 days and allows a person who has been detained to make a written request either on their own or through a friend, family, or attorney for hearing on the need of detention. That follow-up hearing is a probable cause hearing to be held within 5 days of the request to determine whether probable cause exists to detain the person as a person with a mental illness who is in need of treatment. You do have the -1 amendments, which replace the measure and go through the pertinent ORSs and change 5 days to 10 days. We have Judge Wilkie joining us by phone.
So, yes, we have a number of individuals who want to give testimony today. We will get through everyone. What I'm going to do is we're going to start off with Judge Wilkie, who was not able to be here in person, so we will have him on the phone if he's not already waiting for us. Judge Wilkie?
Thank you, Senator Przanski, Vice Chair Thatcher, and Senators. Thank you first for allowing me to testify by telephone. My name is Pat Wilkie, and I'm a Circuit Court Judge in Josephine County and have been since February of 2006. The rest of my background is included in my testimony on March 18, 2019, concerning Senate Bill 763. As I mentioned then, I am the co-chair with Senator Przanski of the work group to decriminalize mental illness. During our year-and-a-half of meetings, the work group took up the issue of Oregon's current 5-day limit on involuntary mental health holds. Many of our members have on-the-ground experience with the 5-day hold and express frustration. Usually these 5-day holds are used for people suffering from a serious mental illness who are psychotic and thus detached from reality. It is noted that even if that person was willing to immediately start taking antipsychotic medication, there's little chance of it being effective within 5 days. In most cases, no medicine is taken and no treatment is received, and the person is released, oftentimes before the 5-day hold is up. It is not unusual for that person to return to the streets in almost the same condition as when the hold started. Many such individuals continue to recycle in the community until they commit a crime or are taken to jail where their problems increase. Senate Bill 762 lengthens the period of involuntary hold from 5 days to 15 days with procedural safeguards built in so that the person subject to the hold has a right to object and have a hearing. There's also a proposed amendment that would merely lengthen the 5-day hold to a 10-day hold, which would give the seriously mentally ill individual a better chance for stability and recovery. Finally, I have worked on a different idea that would continue the 5-day hold as it currently is, but would provide an avenue to extend the 5-day hold by an additional 10 days under 2 circumstances. First, with an extension, there would be a petition that would state that with the extension, there would be a real chance of recovery and stability that would obviate the need to go forward to a civil commitment hearing, or with good and sufficient reasons, the state simply cannot be ready for a commitment hearing within 5 days. Again, procedural safeguards will be built in this scheme to allow the individual to object and be heard. After the hearing on May 18th, I telephoned several senators to see if they had any follow-up questions. In my discussion with Senator Thatcher, she expressed concern that not only was the 5-day hold perhaps too short, but the six-month civil commitment was too long. We discussed the fact there are many different civil commitment procedures around the country, and we were certainly not bound by the 6-month current limit. For example, in New York State, the initial involuntary hold is for 15 days, which can be extended to 60 days and then further extended to 6 months under certain circumstances. I know that the Oregon Hospital Association was not included in our work group and has expressed concerns about the possibility of the mentally ill individuals being held in hospitals for a longer period of time. That is certainly a legitimate concern. I think the length of the pre-hearing hold and the length of the ultimate civil commitment are issues that may require further work and consideration. If Senator Przansky and this committee also came to that conclusion. The work group to decriminalize mental illness could continue to meet and to work on this specific concept, including the Oregon Hospital Association, emergency room physicians, and any other interested persons or groups. For the committee's information, I'm attaching an article by the Washington State Institute for Public Policy entitled Involuntary Civil Commitment, Common Questions and Review of State Practices. This article does a very complete job of setting forth the length of commitment and the type of commitments in all 50 states. And it's noted in the article that Oregon is only one of 8 states that has the 6-month civil commitment. Most states have a 90-day civil commitment. And so there's all kinds of variations on the theme. And with that, committee, I'm happy to answer any questions that you might have.
All right, let's see first if we have any questions for Judge Wolke. Judge Wolke, I don't think we have any questions for you. I'm assuming you're going to stay on to listen, or are you following us online?
I think I'll try the online. I'm going to keep you on the phone, and try online both.
Okay. The only thing I would ask you to do, if you leave the line open, if you can make certain you're mute, so that way we won't pick up any background if you need to do something while you're listening.
Understood. Thank you, Senator.
All right. Thank you. So we're now going to have Dr. Maya Lopez, come first, and we'll take your testimony, and then we'll get into others.
Good morning.
Good morning.
Chair Przansky, Vice Chair Thatcher, members of the committee. I am Dr. Maya Lopez, representing the Oregon Psychiatric Physicians Association. The Oregon Psychiatric Physicians Association, the OPPA, has been part of the work group to decriminalize mental illness from its inception in late 2017. We talked about a number of concepts. However, the primary focus for most of the discussion was resulted in Senate Bill 763, defining dangerousness. The secondary conversation was about the length of the hold. There are lots of ideas that were brought to the table during that during the work group sessions, and it's our position as the OPPA that we need to go back to the table to have more discussion with, including the Hospital Association and the emergency room physicians and other stakeholders that may yet still need to be identified. Senate Bill 762 the concept, I should say, in Senate Bill 762, I think requires some more thought in terms of how the process works and some more consideration regarding other options that may make that concept work in a better way for the entire state of Oregon. I'm happy to answer any questions you have regarding the clinical idea behind the length of hold. However, that conversation, I think, can also be held in the work group with more stakeholders. Thank you.
All right. Thank you. Senator Manning first.
Mr. Chair, just for a little clarity in my head, we're talking about hospital stays versus jails. Not necessarily. Shanna, can I?
Chair Przansky, Senator Manning, the hope would be that this would be a hospitalization for the purpose of receiving treatment.
Okay.
Yeah, trying to remove from the criminal justice system.
Right.
All right.
Thank you.
Any other questions or comments? All right, I'll go ahead and put this out there. I asked for this to be scheduled for the public hearing. We're going to debate and determine whether or not something needs to be done immediately or not. I know this is something that the work group has been toiling with. One of the concerns I have is the need for something to be different than what we have currently during the interim, before we would come back. The next opportunity that we as a legislature would be able to act on this would be next year. And so that will be part of the discussions that we'll have over this next week and determine whether we need, or if we feel that there's a need to have something modification and then continue with the work group. But not saying which way we're going, but I just want to put that out there, that part of what in my thinking that I wanted to ensure that we're doing the best we can to ensure individuals are getting as quick as access to the treatment that they need, and hopefully not having them in a scenario that's say not necessarily the best or appropriate for individuals suffering from a illness or disease. So any other comments to this point? Thank you very much. We're going to go ahead and take other testimony at this point. I have, for the first panel, we'll call up Kevin Fitz, Danielle Graudin, and Sharon Clue.
Then,
Clue?
is it me or you?
I can't tell if it's a U or a V. Q. Maybe just,
We'll find out.
yes.
So, do you mind if I go first?
That's fine.
Okay, good.
Kevin, you're going first, it
Yes,
sounds like?
yeah.
All right.
Good morning. For the record, Chair, my name is Kevin Fitz. I'm the volunteer with the Oregon Mental Health Consumer Association. Good morning, Chair Przansky and Senate Judiciary Committee. I am here and to say one thing. I have some disappointment and frustration with your civil commitment work group to decriminalize mental illness. To the best that I understand, I feel like there was not a sufficient amount of people who have experienced psychotic disorder, who have had civil commitment, who have been involuntarily detained. I used this yesterday in front of a bunch of my Democratic friends. You would not make policy about women's reproductive rights with 49 men and 1 woman in the room. We saw your list of members that were invited. Beyond one individual identifying as living with a severe and persistent mental illness and having been involuntarily detained, we couldn't find anybody else on your list of members who actually has been through the process. And so I just want to say for that, just for that process alone, I would like you to extend the work group and include 20% of people with lived experience of psychotic and behavioral health issues who have been through the system. I don't know if any of you have ever been psychotic. I've had probably 24, 25 psychotic breaks in my life, and it is like losing your mother. It is. There's a Richie Havens song called "I Feel Like a Motherless Child," and to be in a psychotic state and without anchor in a storm, and the only port in the inn is a psychiatric ward, can be extremely traumatizing. So that's all I want to say. We're against this bill moving forward this session for those reasons, but I brought a whole bunch of eloquent teachers and trainers and friends of mine to also speak to this issue. Thank you.
All right, thank you. Who'd like to go next?
I can.
Okay, that's great. Thank you, both can, I just didn't need one to say, I'm next.
Good morning, Chair Przansky
Yes.
and the Senate Judiciary Committee. And thank you for this opportunity to voice my opposition to SB 762. My name is Danielle Grondin, and I am the Director of Training for Folk Time, which is a peer-run organization. And I work across the state to educate individuals and organizations about mental health challenges and substance use through the lens of lived experience. That being said, as someone who was forcefully hospitalized somewhat recently, I'm feeling upset and scared at the prospect of what SB 762 proposes. So much so that I am here far beyond my comfort zone, if it's not apparent, wholeheartedly hoping you'll hear the wisdom from the fellow survivors in today's testimonies. The 5 days that I was in a psychiatric unit were beyond devastating and only exacerbated the crises I was navigating. I now work passionately to transmute the pain that the psychiatric system has caused me and many others through advocating and educating what we believe true trauma-informed care could look like. And what needs to be known today is that the systems we have created currently to care for our most compromised and marginalized communities often replicate our original traumas. For example, as someone who has survived sexual assault, being forcefully hospitalized, closely reactivated traumatic pains of having my power and my decision-making being taken away. This is only one point of contention I have with the Senate Bill 762. I absolutely oppose the notion of extending the amount of time an individual can be detained. And if we are truly moving towards decriminalizing mental health experiences, I believe this is a step in the wrong direction. Also, including the expertise of people with lived experience in the creation of these proposals is absolutely imperative to create a just governmental process. And I please hope you hear my words and that I trust we can do better. Thank you.
Thank you for coming forward.
Yay, I did it.
There you go.
Hi, I am Sharon Keene, and thank you so much for allowing me the opportunity to speak to you this morning. Senator Prozanski, I want to say that I really appreciate the intent of creating a committee to decriminalize mental illness. That is certainly needed, and I'm in alignment with the idea, but I think how we actually deliver and what comes out of it definitely can evolve. And as Danielle says, I think we can do better. So I want to talk just briefly about the process and the impact. In the process, as Kevin highlighted, did not include significant voice from people who have survived these experiences. And what I want you to know is that there are many of us who have had psychotic breaks, who have had interruptions to our life and livelihood and been, the person on the street who's clearly, out of touch with what we consider shared reality. And yet many of us who have had those experiences have also had an experience of mental health recovery or drug and alcohol recovery. And we are even organized into groups. I mean, we have Kevin's group, the Oregon Consumer Mental Health Association. We have the Oregon Consumer Advisory Council that advises the Oregon Health Authority. We have the Oregon Consumer Survivor Coalition. So if you wanted to find representatives of people who really do have the personal experience of being through the hospital system, being through that detention experience, we are happy to step up and be a part of a creative work group that finds better solutions, because I think what we can all agree on is our current system is broken. It's not working that well. And it's very, very painful to think of creating a situation where the solution is simply like holding people longer. I think we need to be a lot more creative than that. We can instead of putting, an additional $10,000 or more dollars worth of hold time in a hospital, we can put more dollars into prevention and early intervention services that actually reduce the number of people that get to that point and need that kind of service. So I didn't say this in my introduction, but what I do for day-to-day work is I manage the David Romprey Oregon Warm Line, which is a peer support service that is available to everyone in our state. And we save the state millions of dollars every year in prevention by giving people access to a connection where they can work things through and not go into the isolation that can spiral into psychosis and separation. So when I think of what could be done in terms of decriminalizing mental illness, I think we could put a lot more thought into having progressive solutions that actually open opportunities for people to get the services they need, not just held longer to be on psychiatric medications. That can be a temporary fix, but actually providing lower cost services that help people to actually do better internally and to connect to communities of care. So it's not just that we're going to plunk someone in a hospital and spend high dollars for a longer period of time, but we actually have communities and places where people who are in a marginalized space can go and be received and connected to people, because really it's not a hospital that gives us safety, it's our relationships that provide safety. And so I do think that when we get the voice of people who have gone through the experience and know the limitations of the help of a hospital stay, we can offer more and actually save dollars and give people options of being part of communities that will help them to live a good life and stay well. I think that all the voices you're going to hear are evidence of the fact that that's a possibility.
All right. Questions or comments?
Well, I do have
Senator
one comment.
Thatcher.
When I was hearing this testimony, I was remembering a friend who had gotten into a situation, and she ended up going to a hospital, one of the community hospitals, and they had a psychiatric unit, and being put, the description of going through that was, it's like, how was that supposed to improve you? I didn't understand that at all. It was, yeah, thank you for bringing that up.
Yeah.
All right.
Thank you so much. Yeah.
So before you, let me just put this on the record. Judge Wilkie approached me and Shannon some time back wanting to have this work group that we put together. We asked him to reach out to various stakeholders. My understanding is he reached out to a number of individuals and maybe organizations, but I'm not sure, that would have that voice that you're wanting to have at the group that will continue. And so this is maybe for Kevin. The membership list that you are looking at is not complete as to how many invites went out. It's who accepted to come in. I'm not saying that he shouldn't have reached out to you or any other individuals. You're now here, so we have a little bit more information of some other stakeholders. And so I do expect that you'll see an invitation for broadening this out to have more individuals that have unfortunately had these experiences. So thank you very much for coming forward.
Thank you.
All right, so our next panel is going to include, if I've got this right, it looks like Thurston Anderson, or Kristen, that's a K, okay. Becky Child, and I'm going to say Cole, it looks like a C-O-E or C, Carver.
Ready?
Morning to all. Whoever would like to start, just give us your name first and then your testimony, please.
All right, I'll start it because I'm the most nervous, I think. This is my first time doing this as well.
Take a deep breath. We're here to hear you.
I'm good. So, hi, my name is C. Carver. I am a director of peer-delivered services for the Mental Health and Addiction Association of Oregon up in Portland. And I'm here to also make a very brief statement of opposition to this current bill as it is. As a person who has experienced civil commitment and is also living a life of long-term recovery from, ongoing recovery from mental health issues, and somebody who works is part of a committee for high ED and EMS utilization in the Tri-County area, I think that this bill, as it stands, will put a lot of undue hardship on EDs to hold people for a much longer period of time than previous. And also, of course, the human beings involved in this. 15 days in an emergency department or a small psychiatric unit can be quite devastating. And I know this from personal experience. So that's really, I consider myself a stakeholder in this. And I would think that there are many other folks in our community who would like to be involved if given the opportunity in kind of figuring out how to rework this so that it is actually decriminalization of mental illness rather than it seems to be more issue for folks than they currently have, with there only being a 5-day hold.
All right, thank you. Who'd like to go next?
Chair Brzezinski and members of the committee, thank you for this opportunity. My name is Kristen Anderson, and I am here as an advocate who is both a parent who has had to call the police in the face of my son's mental health crisis, and I'm also a person with a diagnosis that puts me at risk of a civil commitment. I have not experienced that myself yet, and would hope I might not need that. I am concerned around some of the issues around due process that seem apparent in this as proposed. And as everyone else is saying, I also echo the support of adding people who have been through the experience onto the committee to help with creating solutions. I have worked in both the child and adult systems as a family peer support specialist and now as a peer support specialist. I have worked with hundreds of people, family members, as well as people using the system, being served by the system, and staff and providers and service agencies. And I have come to the conclusion from my experience that our system is so fundamentally flawed. We not only create new traumas, but re-traumatize not just the people being served, but their friends and family, as well as the people desperately trying to provide services and support. The compassion fatigue, burnout, and what is happening to people trying to provide services and support in our flawed system is another issue to be considered and taken into account. I'm concerned that increasing a hold time at the most expensive and least effective way of providing treatment without looking at the entire system and what can be done to prevent people getting to that point in the first time is a Band-Aid just for a little while. So I really asked this committee, I know that today's the last day. I resubmitted my testimony for 762, and I added some potential amendments to Senate Bill 374 to alter that proposed task force around aid and assist to actually become a task force to look at our entire system. So I would really hope, and I know there's not much time, there's have to be done today, but I'm hoping maybe some of those suggestions could be taken place. I really would like to see our state take a close look. All these little patches and fixes in one area have amazing rebound effects in other parts of our system, and I really think before continuing to progress in all these little types of fixes, we need a really good close look at our entire system and how it does not function to the benefit of the people it's trying to serve. Thank you.
Thank you very much. Let's see if there's any questions for anyone on the panel. Thank you all very much for coming
I have
forward.
not testified yet.
Oh, sorry. I was sorry. That's usually a mistake I'd make on Mondays, not Fridays.
Friday's the new Monday.
Yeah. Becky.
Good morning, Chair Przansky and fellow committee members. My name is Becky Child. I was the sole identified person who participated in the work group. I have to tell you, it was a challenging place to be. It reactivated a lot of my own trauma from being hospitalized. And I have been detained under the 5-day notice in my life, and I found it incredibly a horrific process. Simple things like I had a doctor prescribe a new medication for me, and I just asked to see the PDR. The hospital staff told me I needed a doctor's note to look at the damn PDR. Excuse me, my language, but it just irritates me that they make control issues out of things that have no business being a control issue. I just wanted information about the drug I was taking. That said, Senate Bill 762 has long-term ramifications for the acute care hospital system. We already have a problem with emergency department boarding of people that impacts not only adults but youth as well. And as bad as being held for another 15 days or whatever could be, I can't imagine spending that entire time in the emergency department because there's no room at the inn, because I can't get into a place that at least was theoretically designed for me, though I have some issues about that as well. An emergency department is no place for somebody experiencing extreme emotional distress. I encourage you to pull this bill and let's rework it. Let's involve people who have lived experience. I just can't tell you the thought of what I think and the burdens that are, as this bill is so far, and I have not had time to review the -1 amendments, that puts it on the onus of due process on the individual who's going through the crisis. That makes no sense to me. And I say thank you for that.
All right, well, thank you again for y'all coming forward to see if there are any questions. All right, now just for the record, the PDR is Physician Desk Reference for those
Yes.
who might be wanting to know what the acronym is, but thank you very much.
Yeah.
Mr. Chair,
Yes.
could I just quickly, I imagine that there feels like a lot of pressure when you're like a single person from a group and they wonder, what are you doing inside that group? But just for the record, I heard from you frequently as you were attending the meetings, asking questions and asking for clarifications about processes. So just on the record for those that might wonder, that you were very active and worked very hard in that
All right, thank
process.
Thank you again.
Mr. Chair?
Yes.
I'm wondering if we could have our counsel explain what the due process, how that would work with the dash ones, how that would work.
So, Senator Thatcher, Chair Przanski, members of the committee. So the dash ones just take the current structure that's in place, 5-day hold. At the end of the 5-day hold, there needs to be a hearing on whether the person should continue into a civil commitment. This just extends that to 10 days. That's what the dash ones do.
Okay, I guess I was hearing that it's left up to the person, and so I wondered how
on
that
Senate Bill
process is supposed to
762,
work.
in the underlying bill, there is a process for a hearing before the conclusion of the 15-day period. And during that time, it's a probable cause hearing to determine whether the detention is needed in order, whether the person is a person with a mental illness who is in need of treatment. And at that point, the court determines whether the person needs to remain for the 15 days or whether it was an improper detention.
And I suppose what I'm getting at is, who are the parties submitting evidence, if you will, and
So, Senator Thatcher, there is counsel appointed for the person in the 762 process in the underlying bill. And they would be providing evidence and information to the court. There is involvement of physicians, and there's involvement of the person through their counsel, and the state is represented as well.
I guess I'd be curious at one point to hear how many of these hearings actually happen and how most of them are resolved, I guess. I don't know if there's any information on
Thatcher,
that.
I'm happy to reach out to see.
All right, so just for the record, my understanding, looking at the dash ones, basically this was, call it a stopgap, that was basically going to allow for an additional period beyond the 5 days that are current statute. And it was where the original bill was calling for up to 15, this would be up to 10. And so it was basically trying to give a little bit more opportunity for the evaluations that need to take place and all that. That's what this would do if we were going to move forward, and it wasn't going into modifying any of the existing statute as to the checks and balances and the rules that are used for the process and procedure.
So in the dash one, there would be a 5-day involuntary hold. Where, no. Okay, so, no, I know it'd be up to 10, but where would the hearing take place?
There would not be a stopgap hearing.
No.
Senator Thatcher. Then the dash one amendments, it removes that ability to request an expedited hearing because it took it from a 15-day down to a 10-day. It removed the ability to request the hearing in the middle of that period. So that's what the dash ones do.
Okay. All right, so our next panel is Jack, is it Harak?
Yes, Jack
Hotchick, and then Mary Sophia. While they're coming up, is there anyone else who would like to give testimony today on Senate Bill 762? Jack, I'm going to let you go first.
Okay, good, thank you. Chair Przanski, Vice Chair Thatcher, other committee members, guest member is hiding. Please reject Senate Bill 762. Now, I prepared testimony that I submitted on the 17th.
Yeah, Jack, I need you to put your name on the record again, please.
Oh, excuse me. Formally, it's Yatsek. Hotchuk, I also go by Jack. Yes, and I'll give you information, biographical information. But I did submit initially and wrote on the 16th written testimony that I attempted to submit on the 17th, but apparently the postponement was announced, and so I was asked to resubmit it, and I did it in its original form. As I'm looking through it again, there have been some changes in perspective on what's needed for this, and so I'm going to just kind of abbreviate what I wrote and highlight only a couple of things. First of all, I strongly endorse all of the testimony that is said. We really need the individuals who experience these things to be a guide to those excuse me, I'm a retired psychologist, program administrator for over 40 years. And I've been involved with crisis intervention, civil commitment procedures in 3 of the 5 states I've worked in. I've trained psychiatrists, psychologists, mental health professionals in these very issues. I strongly endorse the idea of having individuals who've experienced this process serve as a primary focal point for organizing decisions about how to proceed. They should be our guide. First of all, I'm a bit concerned about just even the conceptual structure of how this was put together. We now have some blurring of issues. The 5-day hold, which in a number of states was 72-hour hold, and it was actually at one time here, is an evaluation period, just as what was described just moments ago in terms of protocols and procedure, a due process, it's an evaluation period to determine if somebody is to be forcibly held and treated. And yet what we've got is a changing of this 5-day hold for evaluation to a 5-day hold for, we want to see if they respond to treatment. Well, we're supposed to evaluate first to determine, and then have a period in which we move ahead on treatment if the evaluation determined that that was what is needed and necessary involuntarily. And now we have a blurring where, all of a sudden we've got 15 days in which we need more time for the person to respond to treatment. When did the evaluation period stop and the forced treatment decision made start? That is not clarified in this at all. In fact, it's blurred. There's no evidence that extending an evaluation period from 5 days to 15 days is going to result in more accurate assessment and improved outcomes. There's no such evidence. In fact, if we take a look at all of the number of states that were mentioned that actually have only a 90-day civil commitment period rather than a 180-day, the reason those states went to that period of time is because there was no evidence that keeping somebody for 180 days made any better improvement over a 90-day period. In fact, the rule of thumb in any of the professional work is that we want to minimize to the least amount and duration possible medications, hospitalization, and forcible treatment, civil commitment. And yet, this looks to elongate it. This has a number of holes in it that sit there are certain aspects of it that sit in contrast to accepted clinical standards and research that shows what can be effective as best as we know. Let's see here.
And Jack, if
let me
get you
just
to wrap up.
I was going to say, let me just conclude with that, with those points, and emphasize the need to go back. I really appreciated Dr. Lopez's input representative of her group, is that we really need to look at, as also was pointed out by someone else, the whole system and how it fits together. The testimony of 762, 763 has basically shown we need more services and an integrated system, not more forcible treatment. Thank you.
All right, thank you. Mary?
Chair Przansky, members of the committee, good morning. My name is Mary Sophia. I'm the Legislative Director for the Oregon Criminal Defense Lawyers Association. I am here today. I wanted to register some concerns with the -1 amendment to 762. Oregon Criminal Defense Lawyers was represented in the work group over the course of the last year since the summer. I had who I would consider to be a substantive expert with me. Her name is Allison Knight, and she was a practicing public defender whose sole caseload was civil commitments down in Lane County. And she has since moved to Massachusetts on with a new job, and so she's not here today, but she had submitted testimony which was uploaded at the first time that the hearing was posted. And our support, and I guess it would be mild support for the original 762, really focused on the amendments made to 426070 and 426100. Those are the pieces that the -1 actually take out. And so when those pieces are taken out, from our perspective, it's essentially stripping what we consider to be critical due process, and that's what we really talked a lot about from our perspective during that work group. And so if you're going to increase the timeline that someone who has not committed any type of crime but has essentially an imposition by the state on their liberty, there needs to be counsel appointed as soon as possible, and there needs to be a process that person can go through and request a hearing. And when those are taken out, it makes us more concerned about about this proposal going forward. And so I just wanted to register those concerns on the record.
All right, thank you. So just for the record itself, I do want to point out that within our materials of exhibits and testimony that's been handed in, Jack, your testimony from previously has been rolled over here, so it is part of this record as well.
I was asked to resubmit it, so I did that just the other day.
Yeah, so it's here. And also Allison's Knight's testimony is also there.
Yeah, I saw that. Thank you so much, Chair.
All right, so I think we got the record covered. I want to thank you all for coming forward. We're going to go ahead and close the public hearing on Senate Bill 762 and open up our last of our public hearings for today on Senate Bill 810. And Michael, excuse me.